like this one in particular.
Blaine, he ran for president, didn't he?
Blaine, yeah, no, he's a pretty well-known guy. Who was it that beat him? That was it Hayes or somebody? He came close, I thought.
Well, come on in. Find yourself a seat. We'll be beginning momentarily. Well, good evening. I'm Angie Tang, Executive Director of the Committee of 100. I'm so pleased to welcome you to this very first Committee 100 English Forum, right here in the nation's capital, and we are deeply grateful to Covington and Burling for providing ideal venues. The Committee 100 recently launched its new series of programming, and the Speakers Forum provide an additional platform for us to highlight the major issues that we advance in the Committee 100's dual mission, which is to strengthen U.S. China relations and to advance progress of Asian Americans. These discussion forums are conducted in 5 regions that Committee 100 members are concentrated: Los Angeles, San Francisco, New York, here in Washington, D.C., and the Greater China region. Last week, we kicked off the series with our inaugural forum in San Francisco on September 11th. It was a very moving ceremony, presentation of colors, where the speakers that included 2 mayors, the state controller of California, and a panel of experts that talked about the local impact of U.S. China economic and entrepreneurial exchange. And today, right here, we'll be examining a different aspect of our mission, the Asian American advancement, and a topic on Asian American citizenship and the U.S. Constitution promises to be provocative. As you've seen, that we have amassed a very thoughtful panel of experts, and the theme also pays tribute to a very special occasion today. As you may know, that is U.S. Constitution Day, or you may know that as National Citizenship Day. On September 17 every year, there are groups of Americans, new Americans, to celebrate their identity as citizens, new Americans of the United States, of this nation they have come to call home. And citizenship swearing-ins take place all around the country. And today, we do our part to honor that tradition with this special Speakers Forum. And again, this most fitting backdrop, our panel of experts today will discuss how Asian Americans have shaped the U.S. Constitution, and on a macro level, how Asian Americans have made an impact to jurisprudence in the United States. And in our effort to build bridges globally and nationally, the Committee 100 is also very much aware that it's equally important to build bridges locally. And in that connection, we are very proud to have partnered with our supporting organizations right here in Washington, and there are Asian Americans Advancing Justice, AAJC, Asian Americans in Energy, Environment, and Commerce, Asian American Journalists Association, Asian Pacific American Bar Association, DC Chapter, Conference on Asian Pacific American Leadership, Georgetown University School of Foreign Service Asian Studies Program, the Office of Asian Pacific Islander Affairs of Mayor Gray's Office, and lastly, the United States Association of Former Members of Congress. We're very grateful to their support and in many initiatives across the country. And before we begin, please let me go through a number of housekeeping items. First, if you have a cell phone, a smart device, please mute. Take a moment now to take a look and make sure that it's no sound, vibrate, or power off completely. If you should keep them on, please do tweet, do post, to tell people how wonderful this discussion has been. And encourage them to watch the live stream. And remember, you're all there, so keep a bright smile and ask intelligent questions. Next, you can stay in touch with us with the newsletter, and by signing up the newsletter, you will get the newest news of our programming and our events, and you can do that at the registration table. And lastly, you have an evaluation on your chair, and we'll collect that at the end of the evening, and we hope that you will help us improve our programming with your important feedback. And now comes the much anticipated discussion. We'll first hear from the moderator, our very own Dunn, Committee of 100 member and legal extraordinaire. Brian has had a distinguished career as a trial attorney. A former assistant U.S. attorney, Brian is nationally recognized for his specialty in complex business litigation and white-collar criminal defense. And aside from his very successful practice, he is also committed to giving back through pro bono counsel. He has represented high-profile clients such as Dr. Lee, whose case, of course, has become a cause in the Asian American community and the world at large. And that was how Brian's son became a member of the Committee 100. So that's a little teaser there. I hope you would tell us the entire story. Please welcome Brian's son.
Thank you. Thank you, Angie. Although one anecdote about me becoming a member of the Committee of 100, when I was first approached about becoming a member, was right in the middle of the Unholy case, which at the time was, one of these first of many cases where I think involved questions about loyalty of Chinese Americans that we've of the more recent era. And it was sort of funny because I was saying to them, if things didn't go so well in the litigation, they might not want me as a member, but things did turn out okay, and here I am. I want to thank everybody for coming, and on behalf of the panelists, I do need to make one little inquiry of the audience, which is, how many of you have some type of legal background or some familiarity with some of the cases that we're going to discuss today? Could you just give us a show of hands so we have an idea? Okay, I see some hands. Okay, thank you. I mean, this would be helpful to the panelists because we don't want to get too dense on the legal stuff, but it's certainly important from our standpoint and from the standpoint of the Committee of 100 and the other groups who are sponsoring this talk tonight to do some education and awareness about a part of American history that I think many of us would recognize has gone not as noticed or focused on as it should. Certainly in growing up, there may have been some mention of certain of these cases like Korematsu in our school books and some in college and certainly in law school, some of the cases, not all, but some of the cases we studied. But in no way, I think, measures or gives full value to the impact that Asian American court cases and legal matters have impacted U.S. constitutional jurisprudence. Much has been said, certainly growing up, about other cases involving African American groups, such as the Dred Scott case and others, Plessy versus Ferguson and the like. But Asian American cases in U.S. jurisprudence have had a significant impact, I would argue, certainly on or par or on the same level in terms of how it's affected the way in which all citizens, all Americans, lead their lives. So what we hope to do today is try to take some slices of this larger pie of cases that have impacted U.S. law and talk about them in sort of historical context and in their modern relevance today. And we're going to talk about the Wong Kim Ark case, which is a 100-plus-year-old Supreme Court case which established the basic fundamental right that I think we all basically have accepted or come to accept as for granted, and we're going to find out maybe isn't such this evening. The notion that if you're born in the United States, you're automatically a citizen of the United States. But it's a little more complicated than that, which we're going to find out in a moment. We're also going to talk a little bit about the exclusion laws and laws that were passed and treaties that were entered into by the United States government designed to exclude Asian Americans, Chinese Americans from having full access to the rights and the law granted under the Constitution of the United States. And then we're also going to talk somewhat about civil liberties and also the way in which the U.S. Constitution affected Japanese Americans during World War II with the Korematsu case, and talk about how that has impacted and shaped the perception of a whole generation and its progeny of our assimilation into America. Now, as Angie said, we're lucky to have some really good panelists here tonight. It's my pleasure to introduce them to you. To my immediate right is James, also known as Jim Ho. He's the former Solicitor General of the state of Texas at a very youthful age, I might add, and a partner at Gibson, Dunn, and Crutcher in Dallas. I've had the pleasure of knowing Jim since he was much younger, through first his spouse, Allison, who I had the great pleasure of working with me at Jones Day on the Wen-Ho Lee case, and that's how I know Jim, so it's all 6 degrees of whatever. And Jim is a very distinguished lawyer in terms of his accomplishments. As you know from the bio that's been circulated, he's public service is something that he is what he's committed to. He's been in all branches of government, executive, congressional, and he is clerk for both the circuit and for the United States Supreme Court for Justice Thomas. And we're very lucky to have him, and he will be talking today about the Wong Kim Ark case and some of its current implications. To Jim's right is Bob Long, who is a partner here at Covington and Burling, who, again, I have to thank. And I'll make this disclaimer. I think Angie said I'm a partner at Jones Day, across town, another law firm, but we have to tip our hat to Bob and Covington for hosting us here this evening. And Bob is who's the chair of the Appellate and Supreme Court Litigation Group of Covington. He is a former Supreme Court law clerk to Justice Powell, who I consider the father of diversity, and for those of us who go back that far. And he is also a clerk for Judge Wisdom of the Fifth Circuit, and worked in the Justice Department in the SG's office, and is one of the top appellate lawyers in the United States. Now, I don't have a lot of time here. I'm going to have to step it up here since we started late, but let me introduce the subject that to sort of set the table here for us, generally speaking. I mentioned a little bit about the exclusion laws. For many of you might know from our history, Asian American history, that beginning well into the 19th century, laws were passed both federally and in the states, most notably California and the West Coast, where there were a lot of Asian immigrants, designed to exclude Asian Americans from participating with the full benefits and rights conferred by the Constitution. I think we all know from either movies and all these sorts of things about Chinese immigrants coming over and working in the railroads and having laundries and all that sort of stuff. And in no small measure, there were a lot of laundries in California because Chinese were excluded from participating in other sorts of occupations and forms of livelihood. And these laws that were passed in the 19th century and actually many of you may know of the Chinese exclusion law that was passed in 1882 that was repealed whatever the number of years it was, 60 some odd years later in 1943. Those laws have pretty much set the tone for, I think, what we're dealing with here in the United States for Asians. And the history of these laws is documented in some literature. Most notably, Bob's partner, Marty Gold, is the author of a book called Forbidden Citizens, a really terrific analysis on historical treatment of how the laws and the treaties and the governmental executive actions of the executive operated to stymie and exclude particular Chinese Americans and other Asian groups, such as the Indians from India, who were so subject to these laws that the Indian American population dwindled to less than 2,500 people, because so many of them returned to India because of the discrimination and the denial of opportunities to them here in the United States. Historically, I will just, because I have to cut this short according to my timekeeper there, and I'll come back to some of this later if time permits. This just represents the kind of climate, culture, and that we've had experience for over 150 years. And what's interesting is that, like history, certain things repeated themselves. And so we're going to try to give some modern context to some of these historical lessons that you're going to hear tonight. And so I'm going to start with Jim, and then we'll go to Bob after that, and we'll see how much time we have to circle back to some of these other slices of cases that Asians had impacted U.S. jurisprudence. Jim?
Well, thank you, Brian. I am very excited to be here today and to be back in Washington, D.C., where I lived for many years with my wife. I want to start with sort of two personal reasons why I'm delighted. One is just to get the chance to reconnect with Brian. As he alluded to, one of the very first experiences as a young litigator that my wife Allison got to have was to work under Brian's tutelage to represent Wen Ho Lee in his lawsuit against the United States government for the deprivations of civil rights that he suffered. And it was not just an extraordinarily worthy and important cause for him personally, but for the Asian American community more generally, but it was just a wonderful personal experience for Allison and actually through her for me. So it's great to reconnect. The second reason I'm so personally excited to be here is I just want to really applaud and thank the committee for recognizing this topic. I've long thought that there's a lot more constitutional law in our country that has really been written by Asian American litigants than I think most people ever hear about or appreciate. And so I'm just excited that today's program really just focuses laser-like on an issue that I think has been neglected by most people. And as Brian alluded to, we're going to talk about just a couple of them, but there's so much more that we could go into. It's just great to have a chance to begin this conversation. I said that Asian Americans have written a lot of constitutional law, and I use that word deliberately, Asian Americans, because that's specifically the issue in the case that I'm going to be talking about, which helps us to define who gets to be an Asian American, as opposed to an Asian who comes here but is potentially denied the opportunity to become a citizen. And Brian alluded to the fact that we're going to talk about these old cases and their very specific modern importance, and that's certainly appropriate to what I want to talk about. As we all know, we're having a very emotional, ongoing discussion about comprehensive immigration reform. On the one hand, it's been going on for a while, but it's also really kind of received renewed special attention this year. And I don't need to tell you that it's a very emotional, contentious debate. In addition, one of the most highly charged aspects of that already highly charged emotional discussion is the debate over birthright citizenship. As some of you know, the concept of birthright citizenship is simply the notion that if you are born in the United States within U.S. soil with certain very narrow exceptions, you're supposed to be guaranteed as a constitutional matter U.S. citizenship. This principle is under attack. There are people who are engaged in this comprehensive immigration reform debate. There are those who obviously they oppose illegal immigration, but in particular, some opponents of illegal immigration are saying that the only way that we can combat illegal immigration effectively, and therefore the only way that they will sign on to a comprehensive immigration reform bill, is if we repeal birthright citizenship. Specifically, if we repeal birthright citizenship for the U.S.-born children of undocumented individuals. And they say the reason for this, the policy argument, is the prospect of automatic citizenship for their U.S.-born children. It's said that it's as much of a magnet for illegal immigration as job opportunities or government benefits. Now, I'm not here to wade into the pros and cons of this policy discussion. In fact, my whole point is that this entire policy discussion is entirely irrelevant. And that's because of a 115-year-old U.S. Supreme Court decision, a case that involves what I would argue anyway is the most important Chinese American in U.S. constitutional history. Before I get to that case and to that individual, let me set the table for the legal analysis. The legal dispute over birthright citizenship can essentially be boiled down this way. Everybody agrees that the 14th Amendment guarantees citizenship and provides two requirements for this constitutionally guaranteed citizenship. One, everybody agrees you have to be born within the United States. And the dispute is over what the second requirement is. Some would say, I would say, that the second requirement is actually a very simple requirement to follow. You just have to have, at the time of your birth, a duty to obey U.S. law. That's what makes you, quote, subject to the jurisdiction of the United States under the terms of the 14th Amendment. Others would say that the duty to obey U.S. law is irrelevant. What they would say is that the Constitution requires that your parents actually be citizens themselves. They say that subject to the jurisdiction means political allegiance, that you're already a citizen legally required to have political allegiance. My message today is simple. Every traditional tool of legal analysis, and I realize there are some non-lawyers in the room, so I'll try not to be overly legalistic, but every single traditional tool that courts and lawyers use to analyze a legal dispute, all of them point in the exact same direction. They point to the fact that birthright citizenship is a matter of constitutional right, and that it is so not just for the children of passengers on the Mayflower, but also for the children of undocumented persons. In short, the legal test is obedience, not allegiance. And that's so as a matter of constitutional text, common law history, congressional debates, Supreme Court precedent, and executive branch interpretation. I will go through them quickly. First, as a matter of constitutional text, just reading the First Amendment of the 14th Amendment, the first sentence of the 14th Amendment, it says that all persons born or naturalized in the United States, and two, subject to the jurisdiction thereof, are citizens of the United States. So what does it mean to be subject to the jurisdiction of the United States? That's the whole legal dispute. I would submit that the plain meaning of this is very simple. It's the duty to obey U.S. law. If you think of somebody saying that a company is subject to the jurisdiction of the FCC, or a person is subject to the jurisdiction of a particular court, obviously all we're trying to say is that you are, as a company or as a person, required to obey whatever that federal agency says, whatever that court decides. Not that long ago, Justice Scalia actually wrote a separate opinion in a case noting that when Congress uses these terms, they're just referring to legal authority, to the legal authority of Congress to regulate a particular person or particular entity. Notice what doesn't matter. It is entirely irrelevant what your immigration status is, what your parents' immigration status is, whether you have national allegiance or political allegiance. Nobody asks if AT&T has political allegiance to the FCC when they're asking whether the AT&T is subject to the jurisdiction of the FCC. Now, obviously, the term subject to the jurisdiction, that language has to mean something. Otherwise, it wouldn't be in the Constitution. It has to exclude, therefore, somebody. And it does. It simply excludes anybody who does not have a duty to obey U.S. law. If you are a child of a foreign diplomat here in the United States in a diplomatic mission, you are not entitled to guaranteed citizenship. If you are an enemy combatant, something that used to be an old doctrine but is in the post-9/11 environment come back into the fold, that would not entitle you. If you're the U.S.-born child of an enemy combatant, you would not be entitled. But that's it. Everyone else, as long as you're born in the United States and your parents have a duty to obey our laws, you are guaranteed citizenship. This is entirely not just what the text provides, but consistent with the common law history of our country. The 14th Amendment is not some newfangled concept. It's really just codifying an age-old, ancient doctrine of English common law known as jus soli. This doctrine provided for automatic British citizenship so long as you were born on British soil, including individuals born to non-British citizens. And there was a common law exception that, as we talked about, for foreign diplomats and combatants. This English common law was brought to the country, brought to the United States as part of our early American colonial practice. It then became part of our early state practice. And then along came the infamous Supreme Court case of Dred Scott, when the U.S. Supreme Court decided that there would not be U.S. citizenship for the U.S.-born children of slaves. Congress adopted the 14th Amendment to ratify and constitutionalize the jus soli doctrine and to overrule Dred Scott. I don't know how much time we have. I may skip past the congressional debates.
No, we're just going to flash up things.
We're good? Okay.
Keep on going.
Well, let me talk about the congressional debates then, if you don't mind. I don't want to put too many people to sleep in the room, but the congressional debates are actually very interesting, particularly for Asian Americans, because we actually played a big role in the debate over the 14th Amendment. And what you'll learn from the congressional debates over this citizenship clause is that basically Congress wanted to do two things. It wanted to include the U.S.-born children of foreign nationals like the Chinese, specifically the Chinese, and Congress wanted to exclude Native Americans, Indians, due to their unique legal status in our nation's history under the doctrine of tribal sovereignty. So Native Americans, Indian tribes were excluded, but everybody else was included. In the main debates over the citizenship clause, everybody agreed, both the people who wanted the 14th Amendment, the people who wanted the citizenship clause, and the opponents, the people who did not want them, everybody agreed that the citizenship clause would codify the English common law doctrine of jus soli. Indeed, there was an explicit debate in the Congress about whether this was the right thing to do. So the House passed the 14th Amendment, and they did so when there was no citizenship clause. It comes over to the Senate, and this is when Senator Howard introduces the language that we now know as the Citizenship Clause. He introduces it, and he explicitly explains that what he's trying to do is to basically codify the jus soli doctrine. An opponent of his, Senator Cohen from Pennsylvania, used some rather racially tinged language to oppose this. He agreed with the understanding of it, he just did not like it as a matter of policy. And he said, and I quote, "Is it proposed that the people of California are to remain quiescent while they are overrun by a flood of immigrants of the Mongol race? Are they to be immigrated out of house and home by Chinese? It is utterly and totally impossible to mingle all the various families of men from the lowest form of the Hottentot up to the highest Caucasian in the same society." So it's clear he agrees with what I'm saying in terms of the understanding of what this clause means, and he's opposing it vociferously precisely because of what it would do. Senator Conness of California rises and says that in fact the U.S.-born children of Chinese should be covered, deserve the same civil rights as everybody else. And the Senate adopted this clause, adopted this understanding, and rejected Senator Cohen's racial appeals. So just to summarize, there was a consensus in Congress that the citizenship clause would cover foreign citizens, so long U.S.-born citizens of foreign parents, so long as they were not immune from U.S. law. The only debate was not over the meaning of this provision, but about its wisdom. Of course, just because Congress says so doesn't mean people are not going to fight about it in court, and that brings us to the famous 115-year-old precedent, United States versus Juan K. Mark. Juan K. Mark was born in San Francisco, California. His parents were Chinese nationals who, as a matter of federal law and treaty, were barred from ever becoming U.S. citizens themselves. But what about their child, Juan K. Mark? By being born in the United States, wasn't he guaranteed U.S. citizenship under the 14th Amendment, regardless of what some congressional statute or treaty might provide? Well, we're going to find out, because that's exactly the legal test that came about for this individual. He traveled to China on a temporary visit, and then when he tried to come back to the United States, he was denied permission by the United States government. The government argued that, notwithstanding the 14th Amendment, he was not a U.S. citizen and would not be allowed to enter the United States under the Chinese Exclusion Act. So the legal question was, does Wong Kim Ark have constitutional rights under the 14th Amendment, which would then trump and invalidate the contrary provisions of the Chinese Exclusion Act? The United States government said, not only did they say no, they had some pretty strident language in their Supreme Court brief. They said, quote, the Chinese laborers are apparently incapable of assimilating with our people. And that's why Congress passed this law, and that's why the 14th Amendment should not be construed to stop it. Thankfully, the court rejected the United States position and sided with Wong by a 6-2 vote. There's so much more to talk about on this subject and on so many other cases. I don't want to monopolize the time. I'll just end with this point. It remains to be seen, of course, whether or not comprehensive immigration reform is going to pass. It seems like it's been a very long fight, and it continues to go on. And it remains to be seen that if it does pass, what kind of bill will pass? Whether opponents of illegal immigration, particularly those in the House, will see if they are able to extract their pound of flesh from the bill by getting a repeal of birthright citizenship added to the bill. I don't know if that's going to happen or not. But if they do that, and if the law is signed on that basis, I can guarantee you of two things. One, that issue will be challenged in court, and two, that a Chinese American from San Francisco will once again, that precedent will once again play a starring role in our nation's continuing drama, that is the United States Constitution. Thank you.
And on this whole subject of having, there's terms of art nowadays called inclusion, exclusion, having access, being able to have the rights that are afforded under the Constitution. I think in turning to the Korematsu case, we're going to maybe examine this issue in the context of even if you have certain rights, you can find that those rights can be suspended. And the Japanese-American experience during World War II is illustrative of what can happen. And I remember, and whether you're Jewish or you're a Japanese-American, whatever, and you think, oh, how could that ever happen, kind of thing, but it did. And people say don't forget because it can happen again. The relevance of Korematsu and the Japanese-American experience during World War II is relevant, obviously, then, and it is now, as Bob Long will talk about. And I did promise to say this because it's true. Covington and Burling was counsel or co-counsel, whatever, with for Fred Korematsu when he argued his case in front of the U.S. Supreme Court. So Covington has a long and deep connection and commitment to this issue. So, Bob?
Well, it's really an honor to be with you tonight. I want to tell you Covington does a lot of pro bono work, but even today, many decades later, the argument in the Korematsu case is often mentioned as one of the proudest, most important pro bono projects that any of our lawyers ever did. So let's come forward a little bit in time. That's a great introduction because of birthright citizenship, by the time we get to World War II, it was accepted that the second generation Japanese Americans born in the United States were citizens of the United States. The first generation, the Issei, were barred from becoming citizens. The second generation, the Nisei, were, because of the Constitution, allowed to become citizens, but they were still subject, even before World War II, to tremendous discrimination. They were not allowed to buy property. They were not allowed to rent property. They were not even allowed to share crop. And these were state laws that California and then Washington and Oregon would enact. So really quite a lot of de jure discrimination by law. And then things got much worse. Then World War II came. Following the attack on Pearl Harbor, there was great fear that the Japanese government was planning an attack on the west coast of the United States. And the response of the U.S. government was to order, with the full approval of President Roosevelt, and backed by a statute enacted by Congress. There was an order that about 120,000 Japanese Americans who were living on the West Coast, including about 70,000 U.S. citizens, would leave their homes and businesses on very short notice and move to relocation centers that were in very inhospitable locations, and they had to basically abandon all their homes and businesses or sell them for fire sale prices, and then they had to build their own detention centers. There was initially nothing there. So extremely harsh treatment. Fred Korematsu was an American citizen. He knowingly violated civilian exclusion number 34. He remained at his home in San Leandro, California. He was arrested. He was convicted. He challenged his conviction, and his case got all the way to the U.S. Supreme Court. By the time the court decided his case in 1944, the tide of the war had turned, and there was no danger that the Japanese Empire was going to invade California. But nevertheless, the Supreme Court upheld Korematsu's conviction by a vote of 6-3, and that decision continues to reverberate today. You mentioned Dred Scott, and sometimes Korematsu is mentioned as among the handful of worst Supreme Court decisions ever, along with Dred Scott and a few others. The majority opinion for the 6 justices in the majority was written by Justice Hugo Black, who ironically is regarded generally as a champion, great champion of individual liberties. And he actually began his opinion by saying that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect, and courts must subject them to the most rigid scrutiny. Now that's actually a very high standard, and it was the first time the court had announced that standard, and this was in an era before Brown against the Board of Education, when there was not only a lot of discrimination against Asian Americans, but segregation in the South was a legal system. So that was a fairly bold statement, and it's actually, that standard has been used to strike down many other racially discriminatory laws in subsequent years, but not this one in the case where it was announced. The majority said they would have vacated this conviction as unconstitutional if it involved the imprisonment of a loyal citizen in a concentration camp because of racial prejudice. But they said that's not what happened. They said Korematsu was not excluded because of his race, but because the United States was at war, the military authorities feared an invasion, and they believed that the exclusion orders were justified by the military urgency of the situation. And the majority relied on a case it had recently decided, Hirabayashi, which upheld a curfew order that required all Japanese Americans in the West Coast military areas to remain inside their homes from 8 p.m. to 6 a.m. That's what the government came up with before they decided that wasn't enough, and everybody had to be moved to internment centers. And the court had earlier upheld that curfew. And the court said, well, we acknowledge that complete exclusion from the area which is one's home is a far greater deprivation than a curfew. But they said we're going to defer to the military authorities who decided that a curfew was inadequate protection against espionage and sabotage. And the majority refused to accept the arguments made by Korematsu and his lawyer, Charlie Horskeep from Covington and Burling, that these dangers of espionage and sabotage were overstated, and they really hadn't found anybody engaging in sabotage. I believe it's true that at the very end of the war, not a single Japanese American had been convicted of sabotage, and not a single Japanese American had been accused of sabotage. But nevertheless, the majority said at the time these orders were issued, the military authorities thought there were some disloyal individuals among the many loyal Japanese Americans, I'm quoting here, and that the disloyal individuals could not readily be isolated and dealt with. And so for that reason, all the Japanese Americans had to leave their homes and go to internment camps. Now there were 3 dissenting opinions, and each dissent is noteworthy in its own way. First, Justice Murphy, who began his dissent by stating that this exclusion falls into the ugly abyss of racism. And that was remarkable because that was almost the first time that the word racism had ever occurred in a Supreme Court opinion, and it occurred in a few more Japanese American cases in the 1940s, and then disappeared from the U.S. reports, the Supreme Court opinions, for another 20 years or so, until 1966. Justice Murphy said some things that probably a lot of us would say today. He said that this exclusion order deprived Korematsu of due process, deprived him of the right to live and work where he chose without any hearing, deprived him of equal protection of the laws in the absence of any immediate, imminent, or impending public danger. He admitted there was this very real fear of an invasion of the West Coast. He said, that's real, I accept that, and it's maybe sort of hard for us to put ourselves in that position today, but he said that part was true. But he said, I don't see any reliable evidence that Japanese Americans were disloyal or posed any special threat to defense installations or war industries. And he said, and quoting from him, he thinks this exclusion was mainly based on, quote, questionable racial and sociological grounds, not ordinarily within the realm of expert military judgment. So that was Justice Murphy's very ringing dissent. Justice Jackson had a dissent where he said also this is really not consistent with the most fundamental assumption that underlies our system, which is that guilt is personal and not inheritable. But he then went on to distinguish between military orders issued by military officers and judgments issued by a court. And he said a military order, he said, first of all, the essence of the military job is to marshal physical force, to remove every obstacle to its effectiveness, and to give itself every strategic advantage. So basically he said military officers are not thinking about the Constitution or civil liberties. And then he said a military order, however unconstitutional, is not apt to last longer than the military emergency. But once a judicial opinion rationalizes the Constitution to show that it sanctions such an order, the principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of urgent need. So Justice Jackson's solution to this case was he would have held that the civil court could not be made to enforce an order that violates constitutional limitations, even if it's a reasonable exercise of military authority. So he would have held that the conviction of Fred Korematsu was unconstitutional. But he made an interesting additional statement. He said, I'm not saying I would have interfered with the military. So he seemed to be saying he would have allowed all the Japanese Americans to be rounded up and taken off to the internment camps, but then at some later time he would have said, when the danger had passed, well, that was unconstitutional, don't expect the courts to bless it, but we won't interfere with it either. So not quite as ringing as Justice Murphy. And then the third dissent was by Justice Roberts, who, if you remember him at all, you probably remember him as the switch in time that saved 9 back in the New Deal, when the more conservative justices were striking down a lot of the New Deal legislation. Franklin Roosevelt came up with this idea to appoint a bunch of new justices who would outvote the conservatives, and just as that was sort of pending before Congress, Justice Roberts started voting to uphold some of the key New Deal legislation. So he's referred to as the switch in time that saved 9, the 9 justices. But it's noteworthy in this case because right after Pearl Harbor, Franklin Roosevelt appointed Justice Roberts to chair a commission to look into the Pearl Harbor attack. And it was basically to find out whether there had been some dereliction of duty by the commanders, the American commanders. But that report, which was produced in great haste and under great pressure, actually credited information that this commission received that Japanese Americans in Hawaii had engaged in espionage prior to the attack on Pearl Harbor. And that was in fact part of what led to this feeling that, oh, we've got to do something about all the Japanese Americans out on the West Coast. But nevertheless, Justice Roberts dissented and said this was unconstitutional. He didn't say anything about his prior work, but the sort of logical explanation is he had become skeptical of the claims that the military was making, and it had emerged that these claims of espionage in Hawaii were greatly overstated. So he was the third dissenter. So fortunately, the story of Korematsu does not end with that decision upholding Mr. Korematsu's conviction. Actually, the very sort of first event that began to limit the decision happened on the very same day. The day the court issued Korematsu, it also issued a decision in a case called Endo, ex parte Endo, which unanimously held that another Japanese American internee, a woman, who had actually filed a petition for a writ of habeas corpus, and had said, you know, you're holding me in detention, you're depriving me of my liberty, and you have no basis for doing that. The court unanimously held that she was entitled to be released. The government conceded that she was not any sort of threat to security. And they said, well, they actually said, well, we don't have to reach any constitutional issues because we don't read any of the President Roosevelt's order or the congressional statute or any of the many military orders to prevent her from being released, which was a bit of a stretch. And many people have pointed out how can Korematsu and Endo both issued on the same day, you know, fit together, because essentially they were saying, you know, Fred Korematsu should have been released too. Everybody agreed he wasn't a threat to security, and if, you know, if they shouldn't have been rounded up, if they had to be released, why should they have been rounded up in the first place? So the court seemed to recognize there needed to be some limits to this. They issued the Endo decision, and as a result, the government fairly promptly began to release the Japanese Americans from the internment camp, and the process began to end, not in a very nice way. They gave the people a one-way bus ticket, $25, and I understand some of them were not allowed to move back west, so they weren't allowed to go back to their homes, I think, including Fred Korematsu. So he first ended up, I think, in Salt Lake City. But they began to dismantle the internment camps. In subsequent years, Korematsu has been much criticized. The Supreme Court avoids citing it. It's more likely to cite the dissents. In 1980, a commission was appointed to investigate the Japanese American internments. It concluded that the internments were not justified by military necessity, and they arose from a combination of, and I'm quoting, race prejudice, war hysteria, and a failure of political leadership. And in 1988, as you may know, Congress formally apologized for the internments and provided modest financial reparations to surviving internees and their families, including Fred Korematsu. He received $20,000 for his experience. Then in 1983, Korematsu's conviction was overturned by a federal judge in California who issued an extremely rare writ of coram nobis, which virtually never happens in our legal system, and basically found that the federal government had knowingly provided false information to the Supreme Court about the extent of the danger, and that therefore his conviction could not stand. And in 1988, President Clinton awarded Fred Korematsu the Presidential Medal of Freedom, which is the highest civilian honor our government can give any person. And he said, in the long history of our country's search for justice, some names of ordinary citizens stand for millions of souls. Plessy, Brown, Parks. To that distinguished list today we add the name of Fred Korematsu. And then in 2011, the acting Solicitor General of the United States issued a remarkable statement criticizing the man who was the Solicitor General at the time of the Korematsu case, Charles H. Fahey, for having, I'm quoting here, for having suppressed critical evidence in both Korematsu and Hirabayashi, the curfew case. And he specifically mentioned a report called the Ringel Report that came from the Office of Naval Intelligence in 1942, so very early in the process, and concluded that only a small percentage of Japanese Americans posed a potential security threat, and the most dangerous were already known to the government or already in custody or both. And now this report was disavowed by the Office of the Chief of Naval Operations, but not for any particularly good reasons. And the Solicitor General at the time was told by his staff that failure to look into the conclusions of the Ringel Report, or at least to disclose its existence to the Supreme Court, and again I'm quoting from this statement, might approximate the suppression of evidence. But the Solicitor General decided to say nothing about it to the court. So the court didn't know about it. Fred Korematsu didn't know about it. Charlie Horsky, his lawyer at Covington and Burling, didn't know about it. So with all of those good developments since the Korematsu decision, you might think that we have now arrived at the state, as described by Justice Murphy in his dissent, where all residents of this nation are treated at all times as heirs of the American experiment and are entitled to all the rights and freedoms guaranteed by the Constitution. But I would close by saying the issues are not finally resolved. Korematsu has never been formally overruled, even though it's been greatly limited. And former Chief Justice Rehnquist wrote a book about the laws in wartime. And at the very end of the book, he made the statement, "There is no reason to think that future wartime presidents will act differently from Lincoln, Wilson, or Roosevelt, or that future justices of the Supreme Court will decide questions differently than their predecessors." So, the lessons of Korematsu are ones we still have to absorb and confront in the American future.
Well, future and present. I would ask you, Bob, I know we talked before the panel began about the relevance today because of Guantanamo and post 9/11, where there was a specter for Muslim Americans and others, that this possibility that the fear, or national security, which is another subject that impacts Chinese Americans significantly today, but for Muslim Americans and others, the cry of national security is a justification for many things, whether it's electronic eavesdropping or what have you, but in the context of Guantanamo and other cases, doesn't it still have some, Korematsu still have some relevance today as we speak?
Well, that's a great question, and you know, I think all of us in this room did live through 9/11, and so, you know, the fear of the Japanese Empire invading California may now seem very unrealistic, but we can all remember after the attacks on the World Trade Center and the Pentagon, the concerns that, look, we have to take some very serious security measures here to protect against the next attack. And indeed, you know, the government did not say, well, we're going to round up everybody who's, you know, of Saudi Arabian descent, or, you know, so they didn't try to do what they did to the Japanese Americans in World War II, but they did adopt some pretty extreme measures. You know, at first, President Bush took the position that he could, you know, at his desk, take a white piece of paper, say, you know, arrest John Smith, and that person would just disappear. And who was a citizen of the United States living in Chicago or, you know, wherever. That was sort of their initial position. And, you know, again, Congress supported a lot of this. There was, you know, a lot of congressional support for this and a fair amount of bipartisan support. The Supreme Court, by bare majorities, did pare back on some of the measures that the President and the Congress thought were justified and necessary. And I think Korematsu was very much in their minds as they tried to strike that balance. But it very much goes to the point that it's not sort of a one-sided issue where you say, oh, obviously this is easy because these are real threats to security. And I think as Justice Breyer said, what happens is we tend to go overboard and overdo it in trying to protect against security threats. And cases like Korematsu teach us to try to have a measured response even in times of great peril.
To the extent there's any silver lining in all this, I think from my perspective, some of these cases and these issues have helped to galvanize the Asian American community, our communities. We have, in the issue of Korematsu, there beginning whenever it was in the 70s and 80s, a redress movement to seek redress for the relocation experience of Japanese Americans, spearheaded by Asian American community organizations, most notably the Japanese American Citizens League. Certain congressmen, men and women, were very active. Bob Matsui, the late congressman from California, and others were very active in pushing for reparations, which ultimately was approved and signed into law by President Bush in 1992. And I think the numbers I have say it was totaling about $1.2 billion in reparations, with an additional $400 million that was signed into law by President Bush. So the Asian communities haven't been known for being vocal or having arguably an NAACP type organization, or others who have become more vocal about pushing for Asian American access and due process. But we're getting there, and for instance, in the Exclusion Act realm, most recently within the last year, we've had some action by the Congress in terms of recognizing and apologizing for the Chinese exclusion legislation, which had been repealed some 60 years later in 1943, and only as a result of China being a wartime ally of the United States, and Madam Chiang Kai-shek and others influential in the United States who are supporting the repeal of the legislation because of the war. But I tend to view this thing as cyclical in history. Chinese Americans have had an up and down relationship. During World War II, it was sort of on the up, and then the 50s with the Cold War and with Red China, it turned back in that direction, and then following the Cultural Evolution and some more negativity, and then more recently in the late 1990s, beginning with the campaign finance cases and the technology transfer and espionage cases, we now find ourselves in yet another era when Chinese Americans are subjected to deprivation, arguably, of due process and civil rights in some of the loyalty cases, the espionage cases, and the economic espionage cases. But nonetheless, as I said, there's been some good in it. Some of these cases, like, how many of you know the Vincent Chin case? Can you raise your hand? Okay, most of you know the Vincent Chin case, and as a young lawyer, that case galvanized many of us, because there weren't that many Asian American lawyers in the 70s and 80s, but the Vincent Chin case ultimately led to the founding of the National Asian Pacific American Bar Association, NAPAVA, because of the recognition that we needed a national voice through our legal organization to speak for the community, to support the efforts of ALDEF and some of the other Asian Law Caucus and other groups that were more regionally located. So again, out of some of these cases, like Vincent Chin or even Wen-Ho Lee, have been situations or contexts where the community has found themselves at times galvanizing and recognizing that we have to step up and be more vocal. And speaking of the Chinese exclusion laws, we have Michael Lin here, who's a member of the Committee of 100. I just wanted to call on Michael for a couple of minutes to talk about the 1882 project, which the Committee of 100 and other organizations were supportive of, and also some background behind that project and some of the efforts that were made to try to correct some of the egregious actions from the 19th century directed towards Chinese Americans. You just talk from there, whatever you're comfortable with.
Anyway, thank you very much for giving this opportunity. Just I was notified just a few minutes ago, so just want to make it very short.
Sorry to put you on the spot.
No problem. No. Anyway, as Brian mentioned, that about 131 years ago, in 1882, a serious law was passed to exclude Chinese and subsequently including all Asian Americans. And that was the first time in U.S. history a specific group was excluded from entering the country. And for those already here, they were denied citizenship. Now, they were repealed in 1943 because of the Second World War, for political reason. U.S. and China were allied at the moment. It was kind of embarrassing that this kind of law on the book. But there's no acknowledgement of the injustice at all from the Congress. And that has always been a burden on our community, Chinese American, Asian American community, and the whole community, I think so. So it occurs to us that something needs to be done. So a group of us got together, recruited 5 major organizations: Chinese American Citizen Alliance, Community 100, Organization Chinese American OCA, Japanese American Citizen Alliance, and also a new organization, National Council for Chinese American. With the pro bono support of Covington, Burling, they step up to the plate again. And I just want to recognize my co-chair. Okay, where are you? Oh, okay. For this project, and also the generous support from Japanese American Jewish Committee, Richard. We had the audacity to think that we can ask Congress to really acknowledge the injustice, because looking at the Congress so divisive. But anyway, we did ask for this, and to make the long story short, the Senate resolution was passed just about 2 years ago, October 2011. The House resolution took a little bit more doing, but it was also passed in June last year. So it is well, the 2 resolutions basically acknowledge the injustice of passing these Chinese exclusion laws, and also reaffirm the commitment of Congress to protecting our civil rights. To me, it is gratifying to see our Congress had the courage to acknowledge the wrong they did some years ago. Just with that.
Thank you, Michael. I understand that our final speaker, Congresswoman Colleen Hanabusa, is on her way from the Hill. She should be here momentarily. And I know Colleen is going to speak about some of her personal experiences and perspective, both as a legislator, elected legislator, and also as a person who Japanese American from Hawaii, and comes from a culture and background where these issues about being Japanese American during the World War II experience still remain very strong in the memories of many Hawaiians as well as many Japanese Americans. We're supposed to have a Q&A session, so I don't want to mess that up. We can do that. I do want to mention, though, that again, going back to our general theme initially, there's a whole slew of other cases that some of you may even remember from either law school or even read from the books. Some of you remember the fruits of the poisonous tree as sort of common American parlance. Well, that came from Wong's Son v. United States, if I remember, as well as Yickbo versus Hopkins, which is a particular favorite of mine, because that was a case in the 19th century in San Francisco that involved an ordinance passed deliberately designed to discriminate against the Chinese American launderers who were operating in San Francisco. And although it was race neutral, the ordinance that was challenged, I think it had something to do, you needed a license to operate a laundry in a wooden building or something like that. The case went up to the Supreme Court, and the Supreme Court recognized that it was discriminatory and basically said the ordinance was unconstitutional. Unfortunately, YICWA was sort of largely ignored by the Supreme Court for many years, and Plessy versus Ferguson came down about 10, 12 years later and sort of instituted separate but equal and recognized and validated and upheld ordinances that appeared to be race neutral but really were targeted towards African Americans, much like the YICWA ordinance was. But for those who are more constitutional scholar oriented, in the 1950s the Warren Supreme Court used the YICWA precedent and the principles enunciated in YICWA, as I understand it, to strike down many of the Jim Crow laws and ultimately overturning Plessy versus Ferguson and Brown versus Board of Education. So we had a hand in that as well, arguably. Now, coming from the Hill, doing her job for the taxpayers, it's my pleasure to introduce Colleen Hanabusa, who is, among many of her talents, is also a lawyer by background and training. I know this because we had some common clients that we won't talk about, but so we go way back. But it's my pleasure to introduce her. She is a sitting Congresswoman from the state of Hawaii, 4th generation Japanese American. She, the bio says here she's former labor attorney, 30 years experience, but I come to know her not only as a practicing labor attorney, but a very, very active and accomplished and effective legislator in the Hawaii legislature. And in this day and age, to be an effective legislator is quite the accomplishment in my cynical view. But Colleen is, I'll put in this one promo, she's running for Dan Inouye's seat. She has been endorsed by a lot of very prominent people, including the senator's widow, Irene Hirano. But aside from that, she's here to talk today about her perspective as a legislator, a lawyer, someone whose background, experience, life experiences, I think can lend themselves to the subject we're talking about here today, which is sort of how these cases have impacted not only Asian Americans, but all Americans in general. So, Colleen.
Thank you. Should I go here?
Whatever you want.
Okay.
Good evening, and as we say in Hawaii, aloha. And first I want to thank Angie Tang, Ben Wu, Brian Sun, the rest of the Committee of 100 for this opportunity to talk about a subject that's very close to my heart. And that is probably a combination of the uniqueness of what it's like to be in a state that had an interesting set of roots to the plantation, for example, and a large Asian population, and how that then evolved into issues regarding governance and where people then elevate themselves in terms of politics, education, and all the various professions. And that is really one of the benefits of being from Hawaii. But at the same time, what we in Hawaii lack, to a certain extent, is a perspective of what it's like not to be part of a majority. I am what they call Yonsei, which is 4th generation Japanese ancestry. My great-grandparents immigrated from Japan and settled on primarily the leeward coast of the island of Oahu, which is where Honolulu is. And from that time forward, my family worked in the plantation, started their own businesses, raised families, and passed on both the Japanese culture and values and their appreciation for what it's like to be in, not then the United States, but then the territory government of Hawaii. Some of my early, probably the first ones who immigrated, were under still the Kingdom of Hawaii.
My personal history is as complicated as the history of Asian Americans throughout the United States. For example, I have both grandparents who were interned when one would be considered an American citizen, and the other came at the age of 10. I think the reason they were interned is, as you know, in Hawaii, not many Japanese Americans faced internment, was because they were both founders of the Japanese Buddhist church in our community. That's what we think is what triggered that internment. Now, the other interesting part is that my grandparents spoke very little of the internment. Matter of fact, one was interned on the island of Oahu, and people always think of the internment of Japanese Americans as something that happened on the mainland, but it's really something that we had in Hawaii. Some say because of the ethnic breakdown in Hawaii, you could actually intern, and they did. They interned Germans, Americans, and Italian Americans as well, along with Japanese Americans. Matter of fact, one of my grandfathers was the cook, so he said every day he would go to where the three camps sort of hit an apex, and he would trade rice for bread, because they were all allocated so much rice and so much bread, and that's what he would do. So that about is the only story I heard about what his internment was like. My great-grandparents, which are still alive, did not go to the internment camp. It was only my grandfather, the American citizen. The path that I believe Asian Americans have taken has not been easy at all. And I'm sure, I always love listening to Brian because he's such a great legal scholar, even if I know him in the context of a litigator. Sometimes people don't think those two match, Brian, but it really does in their case. And we all know about the Chinese Exclusion Act, which blocked Chinese immigration, the Gentleman's Agreement between Japan and the United States, which stopped the issuance of basically anyone males coming into the United States, except for Hawaii. And the reason, of course, is because they were the labor. When they need an economic basis, it's amazing how our laws change to facilitate that. And as you know, Hawaii's immigration from Asia originally were Chinese, the Chinese coming in first. Then, because of the Chinese Exclusion Act, they went to Japan, brought in the Japanese Americans. Then after that, went to the Philippines and brought in the Filipinos, and after that, there were some Koreans. But by the time the Koreans were looked upon for immigration purposes, many of them were not really part of the plantation workforce in the traditional sense. And of course, we know the Immigration Act of 1917 stopped all immigration for what is called the Asiatic Barred Zone. And of course, that included the remainder of Asia. When you think about hardships and discrimination, you also have to think about the resiliency of them and how they managed to do this. And let me share with you a story. I was on what we call the Big Island, the island of Hawaii, and I went to a coffee farm. Everyone must know Kona coffee. Kona coffee is our premier coffee. And I had done, when I was in the state legislature, we had created what is called a legacy fund, which then allows for pieces of properties to be held in perpetuity. And one of the issues for the people in Kona was they wanted to preserve the lifestyle of a Kona coffee farmer. And of course, they tended to be Japanese Americans. So what we did was we bought what would be called the Uchida farm and put it into trust. I went there, and it was fascinating for me because though I was a little girl, I still remember certain things about what it was like to grow up on a plantation, sort of a plantation that closed down, but the remnants of it. I learned, for example, that my grandfather ran the public bathhouse. And I still remember as a child, I thought it was such a thrill to go burn the wood to make the hot water. I could do it maybe once, and that was it. And after that, we got regular pipes. But at the Uchida farm, they were still doing that. They were still burning wood to make the hot water. But the most fascinating part is they also preserved the way of cooking, where it was open fire where you put the big rice pot and the rice burnt, and it was a skill of being able to know when to pull the cover off and put it back and take the fire out. And I thought, how did they manage to do it? Because it took so long to take a bath, to cook rice, to do all of that, and yet they managed to do that, plus put in very long days. And that's an important part of everyone's history and heritage, that I think when we forget those things, it becomes something that we have lost and we fail to be able to identify ourselves. We all know the story about during World War II, when the Japanese Americans, for example, would be in internment camps, and you would have their sons, for example, fighting in Italy and elsewhere in the 442nd and the 100th Battalion. The 100th Battalion is called the Purple Heart Battalion because there is no battalion that has had that level of casualty as the 100th Battalion. And yet, they served for a country that put their parents, their kid sisters, their baby brothers, all behind barbed wire. And the question is, why? You know, I was privileged, still don't know how I got it, but I was there in the year 2000 when the Medal of Honors were awarded to the 21 Japanese Americans who served in World War II. And one of my classmates called me and he said, my dad is the recipient but wouldn't tell us. He wouldn't even tell them that he was going to receive the Medal of Honor. They found out because someone else picked up the phone from the White House asking if they were going to attend. He had hidden the invitation and answered the phone because he was home and didn't tell anyone. So when they asked him why he did that, he said, because I served a country that didn't want us, so you would never have to see war. And that's why I did it. So I didn't do it to get a medal. Well, I didn't do it to get anyone to recognize me. But that's the reason why I did it. So I don't want to go forward. This isn't important to me. So the family thought that was absurd. Of course, they all came. But, and what the most amazing part about it is he was in a wheelchair because he was still suffering from the shrapnel that he got in Italy. And I looked at the stage and I thought to myself, how is he going to get up those stairs? There's stairs, there's no ramp, and he's in a wheelchair. To my surprise, as those who were still alive walked in, including, of course, Senator Young, he was on crutches. My friend's father was on crutches. Tsukubashiga was on crutches because he did not want them to see him in a wheelchair. And I thought, they're made of different stuff from us. Absolutely different stuff. I don't know if I personally could do what they have done. But it does show, it does say that there is this thing about Asian Americans, I believe, that makes us as a group just strive within the context of what we are. But that, quote, almost a positive stereotype, I guess you could say, is also one that we now have to deal with. Some of you may know that Bill O'Reilly and I kind of went at it at one point in time because he said that Asian Americans should not be liberal by nature because we are hardworking and industrious. It's a positive statement, right? It's a positive statement. But my point to Bill O'Reilly was, you do us a great disservice because you're stereotyping us one way. I said, I happen to be a liberal. I don't think that's bad, and I think I'm hardworking and industrious too. But I said, that doesn't mean that I can't be a liberal. It's just the way that you're looking at it. And he, of course, disagreed. But it tells you also that there is another part of our image. That is, how do you deal with just the fact that we are stereotyped by so many? I think the way we deal with this is to look at the variety of contributions which have been made by Asian and Pacific Americans. And you know, I can tell you for myself, growing up in Hawaii and going to school and beginning my legal career and entering politics, I had no lack of role models. We have role models all over. You know, after World War II, for example, and thanks to the GI Bill, we had a huge number of those 442nd and 100th Battalion members who came back and who went to school, became lawyers, became the political power. As a matter of fact, in 1954, it is attributed in Hawaii that we had what we call a democratic revolution led by those who actually served in the war, many of them coming back. Now, when people think about this, they say, well, why would it be a democratic revolution? Not to say Democrats or Republicans. You have to understand what was happening in Hawaii. Hawaii had a plantation. So the people who owned the plantation, of course, tended to be Republicans, and the people who were coming back were looking for an alternative. And that's how they became Democrats. And tied to that was many of them who also came back, went to work for labor organizations because it was to help them get out of the plantations, make life better. So you've heard these names: Patsy Takemoto Mink, George Ariyoshi, Sparky Matsunaga, and of course we have Ben Cayetano, who is not quite in this group. He was younger then, but you know, he also was a lead leader. And Senator Dan Akaka, who many may not know, is Chinese American, as well as Native Hawaiian. And of course, the most iconic name we all know is Senator Daniel K. Inouye. But there's someone else, and I'm not sure that people remember him. But the first senator from Hawaii was, of course, Senator Hiram Fong. And he was a Republican, but somebody that we all really recognize and believe so much in. So growing up in Hawaii has, if I sum up, growing up in Hawaii has been very fascinating and a privilege that we have all had, and those of us who've been blessed to do it. Politics in Hawaii is also one that is defined by the Asian community. And so when we look upon the rest of the nation, we come with a different perspective. But I believe we also come with a perspective with a lot of obligation and a lot of responsibility, because to a large extent, we have been privileged to be part of that majority. So I hope that what you find when you look at Hawaii's laws is the fact that we have taken the respective cultures and shown the respect to the people, because I think that is how we can best serve people of not only our state, but of this nation and the Asian community. Thank you very much.
Well, I think this is the segment of the program where I think we've reserved a few minutes for Q&A, and I don't know if, I know there's a microphone out there circulating, but I think are there some questions? Two microphones? Okay, just, anybody have any questions or things you want to throw out? This young lady here raised her hand. I don't know if we can get her a mic, but...
I don't need a mic, you can
Okay, fair enough.
This question has to do with the Expatriation Act. Do you know of any Asian Americans of Japanese or Chinese descent that had to renounce their citizenship when they married a non-eligible alien?
My grandmother.
Your grandmother had
My
done
grandmother.
that. So, because that law came into effect in 1907, how Hawaii wasn't a state yet,
But it
so
applied.
how did it affect you?
Because we were still a territory. So we had the Organic Act in 1900 was when it passed, but we became annexed 1898. So what happened, the only reason I know this is because I had to do one of these things when I was in elementary school, and I had to track my grandparents, and I had to say, where they were born and are they a citizen. And I had to put for my grandmother, born in, two of my grandparents born in Hawaii. My other one came when he was 10. So I had to say she was born in Hawaii, and my other two grandparents were born in Hawaii and they were citizens, but she was not. So the teacher said, "What is this? You did this wrong." I said, "No, my grandmother insists." So we looked it up, and that was exactly the reason why. Because my grandfather, when he came at the age of 10, was not considered a citizen.
Ineligible.
Right.
Alien.
So she, by marrying him, had to give up all rights.
So did she reapply in
Yes.
the 30s?
No, because I wasn't born yet. So she, she didn't reapply
At all.
until, no, she did, but it was like, I think it was like, they told me it was sometime after statehood that she reapplied, but she did not. She just thought that was her fate.
Okay, because I'm asking selfishly right
Right.
now because I'm doing a piece on a particular member of Congress, Gibson,
Right.
whose wife had to give up her citizenship because of this expatriation act of 1907, and she had to reapply in 1933. So I'm a little confused how it affected the Hawaiians because you were in a state, and then I'm curious as to why she didn't reapply
Until later.
until much later.
I think it's simply because, one, she didn't see a value in reapplying, because elections were, I mean, when you think about the citizenship rights, right, it would be her rights to vote and to travel, but they didn't travel.
Right.
So I don't think it really came to the forefront that she was not.
So your grandfather had never had intention to go back to Japan?
No, my
So he emigrated here, or he immigrated?
He came at the age of 10, but his parents were already in Hawaii, so they brought the family. But he was the oldest, so he came. It's kind of a unique story, and just let me explain why. My grandfather, when he thought he would become a citizen, his typical Japanese style, he sent his second son. My father was the oldest. He sent his second son to Japan to take care of his mother, who was in Hiroshima. So that son died in the atom bomb. And because he had just gotten his notice that he was conscripted into the Japanese army, the Japanese government felt an obligation, so they continued to pay my grandfather a stipend for as long as he was alive and for as long as he was, quote, a Japanese citizen. So my grandfather just stayed a Japanese citizen and would go back to Hiroshima every year to visit his son's grave. So that's why he never did. So it was, I think, when they started to make those trips that it became obvious to my grandmother that she better become a citizen.
But how did he re-enter?
With much difficulty. It was always an issue, but it helped that my grandfather got some kind of award from the emperor, so the Japanese consulate would always help him get entry back into the United States, but it depended on whoever the customs officer was when he came back in. Sometimes he'd make it through. Right, it was not easy.
Okay.
Yeah, you're absolutely correct, it was not easy.
Okay.
Yes.
I have a question about the Loose Seller Act of 1946, where I think the panelists would want to respond. So the 1882 Chinese Exclusion Act was repealed by the Magnuson Act, if I'm correct, but that only applied to Chinese nationals, but not all Asian nationals. And so the Loose Seller Act granted citizenship or naturalization to Indian and Filipino nationals. Could you just talk a little bit about how that act came about, why those two specific countries, and what was happening to other Asian countries, or immigrants from other Asian countries in the country?
Well,
Stacking the deck.
I was going to say that's something that I think Marty Gold would really be, who is supposed to speak tonight.
So can you give
And I can only say that if you look at his book, Forbidden Citizens, which I think was published, was it this year? Last year. we'll have the answer to that question. I think I did come across this in some of my background reading with preparation, but I can't really say without screwing it up. So
Okay, so Marty's last name is?
Gold, G-O-L-D. He's a senior counsel here at Covington, right? And he wrote a book last year called Forbidden Citizens. It's really, he's got a great talk that he does about it. Unfortunately, he's teaching a class tonight. He was originally on the panel.
Where does he teach?
Where? Is it George?
GW something?
I think it's George Washington. He's actually going to be here in about, we think, he's going to be here after the program's over, so hopefully we'll be able to get you an answer to that question. Someone, I'm sorry. Oh, hi.
Hi, I'm Jason Dunn with Asian Americans Advancing Justice. We're a nonprofit organization here in Washington, D.C. that works to advance the civil and human rights of Asian Americans. And one of the issue areas that we work on is diversity in the judiciary. So I'd love to hear from the panelists a little bit about how much of the decisions do you think were based strictly on legal analysis, and how much of it really is about, who are the judges, and how important is it, to figure out who these judges are, and, what kind of a difference would it have made if there was an Asian American on the Supreme Court?
Well, I mean, I have two appellate specialists to my right, although I've had more than, I'd say actually some of my most fun experiences as a lawyer in front of appellate courts arguing cases. Now, if I understand you correctly, you're trying to inquire about whether the presence of diversity, perhaps even the presence of an Asian American on Supreme Court and appellate court might have influenced the thinking of some of the judges who made these decisions. Well, it's hard to speculate about that since, there has been none. There's very few in the circuit court, certainly no Asian Pacific American in the Supreme Court. I do have one minor anecdote in that regard. And when I was NAPABA president, about 20 years ago, was when Justice Breyer was up to be confirmed. And I remember distinctly, it's in the record, the four minority bar presidents, from the National Bar, the Asian Bar, the Hispanic Bar, we were all testifying in front of the Judiciary Committee, and I remember saying that I didn't want to have a situation where 20 years from now my son or daughter would be here before the same committee saying to you that there's no Asian Pacific American justice on the Supreme Court. Now the 20 years has gone by, and I fear that my son may have to pick up that mantle, hopefully not. But I guess my initial reaction is yes, of course, the presence of a judge or justice of color certainly would have to impact, you would think, the thinking of his or her colleagues. That's what diversity is all about, I think, as Justice Powell, I think, brought out. But I'll just turn it over to these two guys.
I'd add, I think a number of the justices said that having Justice Marshall on the court affected their thinking on a number of cases because he had a perspective as one of the leading civil rights lawyers and an African American. And I'll mention quickly, I was in court on one of the clerk for Justice Thomas, who doesn't often speak during oral arguments, but several years ago there was a case, actually a couple of cases argued together about cross-burning and whether that's protected by the First Amendment. And I happened to be in court that day for whatever else was being argued, but was listening to it. And in the midst of, what's going on about the First Amendment and how broad First Amendment protections are, and we have to protect speech we hate, and the justices were giving that a lot of credence. And somebody started to talk. It took a minute, for me at least, to figure out who it was. It was Justice Thomas, and he said, when somebody burns a cross on your lawn in the South, and you're an African American, that's not just speech, that's a threat to kill you. It's a death threat. And it seemed to me that was an extremely persuasive statement. The justices all looked just sort of transfixed, and it changed the whole atmosphere of the courtroom. And in the end, I'd have to go back to check, but I think there were two cases. I think they said there is a First Amendment right for the Klan to burn a cross on its own land, but if they do it on your lawn or right across the street from you, that's a death threat, and that's not protected. So that seemed to me to be a very visible example of somebody's background having an influence.
Yeah, I mean, as a matter of legal theory, no, it's not supposed to matter, right? Judges are supposed to follow the law, and that shouldn't matter depending on who the judge is and what their background is. Having said that, you know, our United States Supreme Court has never been comprised of one person. It's always been multi-member. It's been 9 for a long time, but it's always been multi-member. And I think one of the reasons Congress set it up that way is because there's an understanding that you want different voices in the room on any of these, any legal case, and particularly these very challenging, difficult constitutional issues. You know, so we both had the honor of clerking there, but one of the interesting things about the court is that when they really are deciding these cases and debating amongst themselves, it's just the 9. Nobody knows how these conversations happen. But I think we've all been in conversations in small quarters where the people who are participating and what voices are heard affects how that conversation unfolds. So I'll end by saying the National Asian Bar Association, Pacific American Bar Association, and AAJC have really taken the leadership role in focusing on the issue of greater diversity in the federal courts, and recently has achieved a level of success that has not been seen in a long, long time. But I think you're quite right that obviously there are more things to talk about.
Well, I have one other final anecdote in that regard. I clerked at the district court level, and I clerked for a judge who was a World War II veteran. He had a propensity to use terms like Japs around the chambers. We used to chase Japs, blah, 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 blah. And, you know, I would try to correct him, of course, and try to get him to become more politically correct. But the one thing that influenced him was that Bob Takasugi, first Japanese American District Court judge in the Central District of California, and a role model for many of us coming up in the 70s, because he was appointed in 1976, had an influence on my judge, just by being present on the bench. And these two very unlikely sorts actually became very friendly and respectful of each other. One was liberal, very liberal, Bob was, and my judge less so. But it was interesting, as with many, I think, of the relationships that formed both presently in the past in the Supreme Court. Philosophical differences don't always mean that you can't have a good exchange with your colleagues and you learn something and respect them. And I think having the presence of Judge Takasugi on the Central District bench, because he was the first Asian American on the Central District bench, had an impact not only on my judge but the other judges of the bench of that district. And so that is a personal observation where I think it matters.
Can I just add, this is where politics play a role. Hawaii's sitting judges now are not those that are on retirement status. 2 women, Japanese American, Susan Okimawe, Leslie Kobayashi, Derek Watson, the first Native Hawaiian, and Michael Seabright, who is married to a Korean American and attorney as well. So that's why I said it's really a different scenario for those of us in Hawaii, but I do believe that their experiences make a difference. Because when you look at decisions on Native Hawaiian rights, for example, and all these different kinds of issues, I believe it's a different level of sensitivity that they bring with them.
One last question.
One more question from side? Yes.
You mentioned in the beginning that the birthright citizenship is something that's being challenged, and I was wondering how actively is it being challenged, and if so, how does that impact Asian Americans specifically, and what we would be doing about that?
Want to take a shot?
I don't know how many years it's been that people have talked about the importance and the need for comprehensive immigration reform. And it's within that context that that we're seeing this discussion about birthright citizenship. And essentially what it is, there are a lot of undocumented individuals in the country, and that has presented a very serious difficulty, politically speaking, as to how to solve the overall immigration problem that we have in this country. A lot of people who oppose illegal immigration will say, look, we're open to comprehensive immigration reform, but only if we do more to prevent illegal immigration going forward. One of the proposals that's been put forth is repealing birthright citizenship. I don't know where this debate is going to go. They make the argument that people will come in legally or illegally, not just for jobs, not just for other opportunities, but so that their children can be born here and they will become citizens under the Constitution. There are some people who think that the Constitution doesn't say that, and that's why we have this fight. There's some people who say that, look, Congress can get rid of it right now, and then they might be okay with the comprehensive immigration reform bill. So I think one reason that this might come up is if there is that kind of political deal to have comprehensive immigration reform, but to include this provision, then it's Congress directly challenging the meaning of the Constitution. And so how it will affect Asian Americans, I think it will affect the Asian American community significantly, because obviously there are a lot of Asian Americans who are immigrants, come here from another country, and start families here. Their children will be presumably the litigants, the future Wong Kim Arks of our constitutional law, and we'll see if Wong Kim Ark is still the law of the land or if it's overturned by a different court.
Going to Jim's point, there has been some legislation proposed, as I understand, in the last few years. I think Congressman Bitter from Louisiana proposed basically some legislation making it barring the offspring of illegal immigrants from obtaining citizenship status. And then in Arizona, I believe there's been some proposed legislation that basically says that the children of immigrants who cannot prove their lawful status would also be denied those rights. And I guess my understanding is that none of that legislation has gotten traction, but the supporters of this legislation are of the view that if they could get something passed, then the courts will take it up, and ultimately the Art case will be reviewed, and in the eyes of or hopes of these groups or of these supporters of this legislation that it will be overturned. But as Jim pointed out, it's been good law for over 100 years, and we're hoping that it'll stay good law. So in any event, Ben?
I know the time is short, but you told Angie to allow me to ask one final question.
Good.
I wanted to ask the panel, as legal practitioners and legal scholars, looking prospectively at the lower court decisions, are there any cases that affect Asian Pacific Americans that the Supreme Court will grant certiorari on in the new term that starts on the first Monday of October that will have some significance that you'd like to comment about?
I don't think race and admissions is over yet, right?
I can mention
go ahead.
that case briefly. Brian alluded to the fact that I had the honor of working in the Texas Attorney General's office, where I represented the state in some of its kind of higher profile, more difficult constitutional cases. And as a result of that job, I got to defend the University of Texas in a lawsuit challenging its affirmative action policy. The U.S. Supreme Court recently decided that case, but sort of decided and sort of really didn't decide it, just sort of sent it back for further review, and so it's back at the Fifth Circuit, and that issue, may or may not return. I assume it will return to the U.S. Supreme Court in some fashion. One of the litigants will go back to the court, and we'll see if the U.S. Supreme Court takes the case again. But that's an issue that, without question, affects race relations in our country. Asian Americans, of course, there are people on both sides of this issue, but without doubt, the importance of diversity, the importance of expanding educational opportunity in higher education is something that we all will continue to be very concerned about.
It'll impact us. I think there's cases out there now involving preferences, or if that's the word, in government contracts, and that'll affect Asian Americans. I think those are coming down or coming up, as you might put it, and so this is, I think, going to be a hot area.
Well, thank you all. That's all the time we have for questions. And would you please join me in another round of applause for our excellent.
Flew in a couple hours ago. Well, but sometimes.
And especially, the program that we put together benefits a lot from the advice and contributions of members. And I'm so pleased to introduce to you our members. I see Jeremy Wu among us. Jeremy, please stand. Give that We're a small region here, maybe 100 members in the greater Washington, D.C. area, and our vice chair, Benjamin Wu, works very actively with the Committee of 100 office and members here in the region to ensure that our program stays relevant and stays policy strong and retain this quality. And so now I have the pleasure of presenting Ben Wu.
On behalf of the Committee 100 DC region members, especially Jeremy, Michael, and Nancy, thank you all for spending this evening with us tonight. That's especially relevant on this September 17th Constitution Day. We've had a wonderful and informative discussion about Asian Pacific American citizenship and what it means to be an Asian Pacific American here in the United States. You know, we hear the quote, the past is prologue, which originates from Shakespeare's The Tempest. But just down the street, a few blocks from here, it's also engraved on the National Archives building. And it's a testament to recognize that what has transpired in our past can help shape our future. And as we've heard the stories about the lives of Wang Kim Mark, of Fred Korematsu, of Wen-Ho Lee, we know that our futures, our children's futures, will forever be shaped by these significant cases that have appeared before, not just the Supreme Court of the United States, but also have helped shape our nation. And giving it light here tonight is an extraordinary panel. And so I want to thank, on behalf of the Committee 100, the members of the panel who have taken time out of their busy schedules to share a little bit about their experiences and give historical value to some of the cases that we read about and hear about in textbooks. To Brian's son, our wonderful moderator, there is perhaps no other more passionate Asian Pacific American advocate in the Committee of 100. To my old friend Jim Ho, who is trailblazing Asian Pacific Americans in the legal profession and also in our judiciary. Thank you for coming all the way from Dallas. To Bob and to Marty Bold and Essentia, and also to Covington and Burling for hosting tonight. Bob, thank you for sharing your expertise and also the firm's leadership with the Korematsu case. And also to Congresswoman Hanabusa, who has been such a terrific leader, who we're so pleased to work with in this Congress and hope that we can continue to work with and expect to continue to work with in many future Congresses, where she will continue to be such a leader for Asian Pacific Americans. Thank you for taking time out of your busy schedule, as well as Congress has reconvened this week. You know, I was approached during the reception today by an attendee who I won't mention by name, but she said to me, you know, you created this program almost as if it was just for me, about Asian Pacific Americans and the Constitution. So I wanted to give credit and tribute the genius behind this day, and the genesis and the inspiration that created our gathering here today. Our executive director of Committee 100, Angie Tang, who came up with that it was important for the Committee 100 to be able to fulfill its dual mission, not just to help shape and strengthen the United States relationships with Greater China, but also to make sure that the secondary mission of the organization, which is to strengthen Asian Pacific Americans in the United States also receives adequate attention. And so thank you, Angie, to our terrific New York team, Mercy, Jennifer, Joseph, all the volunteers who have volunteered their time to be here with us to help put together this wonderful event. Thank you also for the time that you've put in. I should also note that the New York staff has been working diligently, not just on this event here today, but also we had on September 11th a major event that would kick off our speaker series in San Francisco. So our New York team has been working coast to coast in putting together some terrific events. And we look forward to continuing to work with all of you with the Committee of 100. We have with us here today not just Committee of 100 members, but also members who have participated in our Committee of 100 Washington Leadership Program, and also who have participated in our annual conference that was held here in April, this past April. And we will look forward to involving all of you in the next several months in this year as Committee 100 continues to roll out more programs here in Washington. And we invite you as well to participate in our annual conference next year, which will be held on April 25th and 26th in San Francisco at the Four Seasons. So we look forward to continuing your engagement. Thank you for spending the evening with us. Thank you to this wonderful panel for sharing your expertise and your knowledge and helping to remind us once again that Asian Pacific Americans play a very significant role in this country and will continue to shape the future of this country. Our United States Constitution and the life that we all love here in this country. And so thank you, everybody, for being here. Welcome and congratulations on spending your Constitution Day with us. Thank you very much.
What about you?
I was in China last week.
Wow.
Great job on it.
Years ago, he was private and Afghan suffered abuse and yes, and so the military people who have abused him did not get enough punishment and they have to really concern about this. Chinese American and also Asian American feel they're just questioning
hate crimes are a very serious matter, not just society, but in the military as well. With all these situations, there has to be accountability. To have accountability, you need to have conscious bios and email addresses. You can reach it with Marty Bolton. I don't know. Recognizing that in wartime or battle or combat situation, it does create but certainly the idea of harassment of the military contract is unacceptable. My father was a career military officer, and I've shaped in no small measure by my experience there. And he would say, I'm sure, he and his colleagues in the military would say that conduct and supervision of the personnel around Denny is something that should be subjected to some very close scrutiny, as the military should not
an honor.
Allow this opportunity to occur at all, and swift punishment should be dealt with those responsible. Most Americans don't get